All right, let's get right into it. In this explainer, we're diving into the invisible rules that dictate exactly what happens when international borders and the law crash into each other. We live in this incredibly globalized world, right? A business in New York can instantly contract with a supplier in Germany, or even a government agency in Saudi Arabia. But when those deals inevitably go sideways, who actually has the power to enforce the rules? Well, we're going to break down the legal mechanics of global disputes and give you a quick primer on how courts navigate the frankly treacherous waters of international sovereignty. To really wrap our heads around how complex this gets, let's ground it in something super familiar. If a state like South Dakota wants to sue an out-of-state retailer, say Wayfair, to collect sales tax, or if you just want to sue your neighbor because their dog won't stop barking, the path is pretty obvious. You just head down to a local or federal court. We all share a legal system with an established hierarchy, and everybody basically agrees to play by those rules. Take the Big Lane nuisance case down in Natchez, Mississippi. The Big Lanes owned a building right next door to this incredibly popular bar, the Under the Hill Saloon. During the summer, the saloon would fling its windows wide open, and live music would just blast up and down the street all night long. The Big Lanes literally couldn't sleep. Even after putting in thicker windows, it was just unbearable. So under domestic real property law, they sued their neighbor for a nuisance tort, which is basically a legal claim for being an unreasonable annoyance. And guess what? They won. The court forced the saloon to keep its windows shut. Pretty simple, right? The court had the absolute authority to do that. But here is where things get wild. What happens when your neighbor in a dispute isn't a rowdy local bar, but an actual sovereign nation? A nation with its own laws, its own heavily guarded borders, and its own completely independent authority. What if a foreign government breaks a multi-million-dollar contract with your company, or just outright seizes your property overseas? I mean, you can't exactly send the local sheriff over to arrest a foreign country. And this perfectly illustrates a reality that has plagued international business for centuries. Thomas Jefferson actually hit the nail on the head when he said the merchant has no country. See, commerce constantly crosses borders, but legal jurisdiction? Yeah, it usually stops dead at the line. A nation is, by definition, a sovereign entity, which literally means there is no higher authority telling it what to do. So how on earth do we resolve these international disputes without just instantly resorting to economic sanctions or, worse, war? While over time, international customs have evolved into three main pillars for resolving these global conflicts: comity, the active state doctrine, and sovereign immunity. Let's start with the first one, which is essentially just professional courtesy. It's called the principle of comity. Comity basically means that one country will voluntarily respect and enforce the legal decisions of another country's courts. Now, there's a catch. Those decisions have to be consistent with their own laws and public policy. It's kind of like a mutual respect agreement. If an Australian court issues a legitimate judgment, U.S. courts will usually enforce it because our legal procedures are fairly compatible. A perfect example of this in the real world is a fascinating case involving MD Helicopters, which is a company based right out of Arizona. They signed a contract to deliver 8 helicopters to the Netherlands National Police, but they failed to deliver. So the Dutch police sued them for breach of contract over in a Dutch court, and they won. But here's the thing. A Dutch court ruling is literally just a piece of paper if they can't actually collect the cash from a company thousands of miles away. So what did the Netherlands do? They came to Arizona and asked the local courts to enforce the Dutch ruling. MD Helicopters obviously tried to fight it, arguing about obscure differences in the laws, but because of the principle of comity, an Arizona appeals court shut that argument down. They looked at it and said, the legal procedures in the Netherlands are fundamentally fair and pretty similar to ours here in Arizona. The result? The Arizona court ordered the local company to pay nearly $15 million, enforcing a foreign court's ruling right here on U.S. soil. Okay, moving on to our second rule, the Act of State Doctrine. This one is all about respecting boundaries. It basically says that U.S. courts will absolutely not pass judgment on the validity of what a foreign government does inside its own house. If a recognized foreign government makes a sovereign decision within its own territory, our judicial branch stays completely out of it. Now, this doctrine heavily impacts property seizures abroad. Sometimes a foreign government is going to take private property. If they do it for a legitimate public purpose and actually pay you for it, it's called an expropriation, which is legal. If they do it for shady reasons or just refuse to pay you, it's confiscation. But here's the real kicker. Even if a U.S. company gets its property completely confiscated abroad, the Act of State Doctrine often blocks them from recovering a single dime in a U.S. court. Why? Because our courts simply will not play referee for the internal acts of a foreign sovereign. And it applies to regulations, too. Take the Canadian province of Ontario.
They had a rule granting a retail monopoly to certain stores to sell large quantities of beer. Well, a Wisconsin brewer named Mountain Crest felt this violated U.S. anti-monopoly laws, so they tried to sue. But U.S. courts completely threw the challenge out based on the Act of State doctrine. We just don't have the jurisdiction to invalidate Canada's internal regulations, no matter how much it hurts a U.S. competitor or, frankly, how much we might want cheaper beer.
Finally, we reach the ultimate level of protection, sovereign immunity. This is the big one. Traditionally, this doctrine means you simply cannot sue a foreign state in a U.S. court, period. They are entirely immune. It's this massive historical shield designed to keep foreign governments from getting dragged into messy domestic lawsuits.
But, as you might guess, that shield isn't completely bulletproof. Look at this wild case. The descendants of Jewish art dealers in Frankfurt actually filed a lawsuit in a U.S. court against the country of Germany. This was over the Welthenschatz, an unbelievably valuable collection of medieval art. The descendants argued their ancestors were terrorized by the Nazis in 1935 and forced to sell the collection for pennies on the dollar. Germany obviously tried to throw the case out, shouting sovereign immunity, but a federal judge actually denied Germany's claim, allowing the case to move forward. So the huge takeaway here is that immunity is not absolute. In the U.S., the whole thing is strictly governed by a 1976 law called the Foreign Sovereign Immunities Act, or the FSIA. The FSIA spells out exactly when a foreign nation can actually be dragged into court. But make no mistake, if you're the one suing, the burden is 100% on you to prove that foreign shield deserves to be dropped. The FSIA lays out a few key exceptions where a state can be sued: if they explicitly waive their immunity, if they engage in commercial activity, if they commit a tort here in the U.S., or if they're a designated state sponsor of terrorism resulting in injury or death. To see that commercial activity exception play out, check out this scenario. Saudi Arabia used a German construction firm to buy materials for this massive tent project. The German firm bought the goods from a New York supplier named Taconic, but then totally defaulted on a $3 million payment. Taconic turned around and sued the government of Saudi Arabia directly in a U.S. court. Saudi Arabia tried to claim sovereign immunity, of course, but the court said no, because they had stepped into the marketplace and acted just like a private commercial player. They lost their immunity. Basically, if you act like a private business, you get treated like one. Then you have the terrorism exception, which was fiercely tested in a high-profile Supreme Court case, Rubin v. Islamic Republic of Iran. Victims of a horrific Hamas suicide bombing in Jerusalem sued Iran under the FSIA because Iran was a designated state sponsor of Hamas, and they won. The U.S. citizens were awarded a massive $71.5 million judgment against the country of Iran. But here is the catch. Winning a judgment and actually collecting the cash are two very, very different things. To get their money, the victims tried to seize this incredible collection of ancient Persian art owned by Iran that happened to be sitting at the University of Chicago. But the Supreme Court stepped in and said, hold on, you can't just do that. They ruled that while the FSIA allowed the victims to sue and win, it didn't give them a blank check to just strip away immunity from all of Iran's physical property. The balance of international law is just incredibly delicate. As our world gets more and more interconnected, foreign governments are constantly acting as global merchants, buying software, building infrastructure, moving money around. Understanding comedy, the act of state, and sovereign immunity is absolutely essential for anyone doing business on a global scale. But it leaves us with a really provocative question to chew on. As nations continue to jump into the private marketplace, should that sovereign shield completely disappear? Or is it literally the only thing keeping global relations from collapsing into just endless chaotic lawsuits? Something to think about the next time a massive multinational trade dispute hits the news. Thanks for joining this explainer. We'll see you next time.